Morning, Assistant Public Defender Lauren Perry on behalf of Mr. Beach, who is approaching.
We're jumping straight into what looks like a routine morning docket, but don't let the calm tone fool you. Cases like this can turn unpredictable fast. Today's courtroom session before Judge Simpson starts with what seems like a simple adjournment request, but within minutes we're dealing with issues of substance use, courtroom behavior, and the delicate balance between personal rights and legal obligations. Here's the big picture. Mr. Beach is before the court, and his attorney is requesting more time so he can review discovery materials. That's normal. Defendants need to fully understand the evidence against them. But then the conversation pivots to substance use, and suddenly Judge Simpson is probing whether the defendant is under the influence while standing in court. Now, here's why this matters. Even in states where marijuana is legal, courts operate under strict expectations. Being impaired in court, regardless of legality, can affect how credible or reliable a defendant appears. Judges must ensure proceedings remain orderly and fair. And notice the tension building. Mr. Beach defends his marijuana use as medically justified and legally purchased, while the judge focuses on courtroom conduct and sobriety. This isn't just about legality. It's about judgment, responsibility, and perception in a legal setting. We're about to see whether this conversation stays procedural or turns confrontational. And trust me, courtroom patience can wear thin quickly. So as we continue, ask yourself, is Mr. Beach simply exercising his rights, or is he pushing the court's tolerance too far right at the start? Stay with us. Things escalate quickly from here.
State your name, please.
Yeah, Bobby Beach.
Your Honor, we're requesting an adjournment. Mr. Beach, I'm providing Mr. Beach a copy with discovery today. He wants to review it all before next.
Before I adjourn it, Mr. Beach, you had any controlled substance today? Mr. Allen? No. You've had nothing. So if I give you a test, you'll come back clean?
Well, this card right here tells me at your community corrections that I can smoke marijuana and I paid money for it. State of Michigan. Say right here, regulatory cannabis. I paid money, taxes. I should be able to medicate. I just had lower back surgery 2 years ago, St. Joe Hospital. They said either use prescription drugs or use what the state of Michigan provides you, the taxpayers.
Okay. Would that be the only thing that would show up in your system?
That's it, Your Honor. I know.
I'm going to pass the matter. I'm going to let him go on his own. Take a test, come back, and then I'll decide what I'm going to do. Despite your ability to use marijuana on that card, you can't be under the influence when you come into court. You understand that?
Judge Simpson draws a hard line here, and this moment is legally significant. Even if marijuana use is permitted medically or recreationally, courts operate under a separate standard. The issue isn't legality, it's impairment during proceedings. When a defendant appears confused, unfocused, or disoriented, the court has to question whether they can meaningfully participate in their defense. If someone doesn't understand what's happening, the entire process risks becoming unfair. That's why Judge Simpson orders the drug test, not as punishment, but as verification. But notice the subtle friction. Mr. Beach insists he just woke up and isn't impaired. Yet his behavior, not knowing where to go, talking excessively, raises red flags. Judges often rely heavily on observation. First impressions in court matter more than many defendants realize. And let's bring the audience into this. If you were in Mr. Beach's shoes, would you openly argue your marijuana rights in court? Or would you simply comply quietly to avoid escalating things? Also watch how the judge uses humor and firmness, telling court staff to guide him so he doesn't get lost. It sounds lighthearted, but it signals concern about Mr. Beach's awareness. This moment teaches a powerful lesson. Even when you believe you're right, courtroom strategy matters. Because next, Mr. Beach makes a move that dramatically shifts the hearing, challenging his own attorney. and that rarely goes smoothly.
Yeah, I'm not now. I just woke up. I'm not now.
Oh, you just woke up?
Yeah,
That's why you
sure.
didn't know where to go in the courtroom?
Yeah, I just had a
Yeah,
daughter.
okay. No, I got you.
I've been babysitting her
Okay,
this
yeah.
morning. I just
Okay,
woke up.
I'm hearing you. I'm gonna trust you to go over on your own. Let's see what the test reveals.
I'm not smoking coming on court, young.
Really?
Yeah. I'm not.
Okay, all right.
I'm very
Okay.
coherent.
Okay,
I'm
all right.
good.
Then you probably ought to stop talking and go take your test.
Okay.
All right? Yeah, that way. You better, yeah, get an order over to him.
Just a one time.
Mr. Fisher, tell Miss Perrine he better point the way because he's gonna get lost.
Can I address the court, Your Honor?
I'd advise against it. I've advised him to speak to me first.
If you want to address the court, your counsel has advised you that it may not be possible for you to do so, so.
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
Okay, and how do you intend upon doing that?
Now things truly heat up. Asking for a new attorney mid-proceeding is a serious move, and courts don't grant those requests lightly. Defendants have the right to effective counsel, but not the right to endlessly switch lawyers just because they're unhappy or confused. Judge Simpson immediately questions the reasoning, and here's why. Delays cost the court time and resources, and swapping attorneys can stall justice. Judges want proof that communication has truly broken down or that representation is inadequate. But Mr. Beach's complaint is common. He feels he doesn't fully understand the process. And for many first-time defendants, court proceedings move fast, full of legal jargon and unfamiliar rules. Confusion doesn't necessarily mean incompetence from counsel. Judge Simpson strongly defends the public defender, calling him one of the best in the county. That's a rare moment of judicial endorsement, and it signals the judge sees this request as emotional rather than justified. Let me ask you, do you think Mr. Beach genuinely feels unheard? Or is this frustration boiling over because the situation feels overwhelming? Either way, challenging your lawyer publicly puts you in risky territory, and the judge's patience is clearly thinning.
I beg your pardon? I'm hard of hearing.
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
And this is news to me. I did see Mr. Edwards yesterday, and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here and 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have
So what are you not satisfied with?
our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washtenaw County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Well, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're gonna try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I gotta set a date. How much time do you need? You don't like the best that Washington County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I gotta try to come up with some money.
Oh,
Okay. Then second of all, I have to have someone to help me find an attorney.
mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of dental work done.
Pro bono.
Pro bono attorney, yes.
A pro bono attorney,
Yes.
meaning one that is a good attorney that you're not paying for.
Yeah.
That's what you want.
Basically, that's what I'm saying. Yeah.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know. I'm shocked.
I wouldn't challenge that. I wouldn't challenge that.
You would?
I wouldn't challenge. I said, I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
so to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
This is the turning point. Judge Simpson denies the request, and legally, that decision is hard to challenge. Courts prioritize efficiency and continuity, and unless an attorney is clearly ineffective, replacement isn't granted. Notice how the judge carefully gives Mr. Beach an alternative. Hire private counsel if you want someone new. But reality hits fast. Hiring an attorney costs money, and Mr. Beach quickly realizes that's not easy. Then comes the ironic twist. He asks about a pro bono attorney, meaning free legal representation, and the judge reminds him he already has exactly that. This exchange exposes a common misunderstanding. Many defendants assume public defenders are inferior, when in reality they often have more courtroom experience than private attorneys because they handle so many cases. Audience question: would you risk replacing a free experienced attorney with someone you barely know, especially when your freedom might be at stake? The judge ultimately orders them to talk things through, signaling the issue isn't legal, it's communication. But the courtroom drama isn't done yet. Another case is about to bring a completely different type of conflict.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates. Bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off.
beg your pardon?
I'm going to make a suggestion to you.
Yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
No, can you please state your name for the record? Franklin Joseph Milton.
Okay.
Your Honor, we are asking for an adjournment in this matter as well. The adjournment is as a result of, we sent a request for consideration for an offer to the prosecutor. We did initiate the negotiations. We're just still working on those. So I think a short adjournment would do it. Yeah, if the court so allows.
Oh, you done?
Yes.
Any response from the people? Probable cause conference, June 13, 2024, 9 a.m. Bond continue.
Your Honor, if I may briefly.
That's where we're going. Go ahead.
I know. It's my understanding that Mr. Melton has CMH Act Services set up. Tom Kloss is the individual who's assigned to the case to his matter. He has a set up keys and knows where Mr. Melton's going to be staying. Should he get out?
We now move to a separate case, but the tension shifts from courtroom behavior to release conditions. This time, the issue revolves around whether the defendant has a stable residence suitable for home confinement. Here's the legal breakdown. Before granting home confinement, judges must confirm that the location is real, safe, and verifiable. Courts can't rely on assumptions. They need documentation or reliable confirmation. And here's the complication. Addresses keep changing. One was given earlier, another appears now, and confusion arises over where Mr. Melton actually lives. Judges become cautious when facts aren't consistent. Home confinement isn't just about letting someone go home. It requires monitoring, compliance, and services support. If the setup fails, public safety concerns arise. So here's the audience engagement moment. Do you think courts should take risks to support rehabilitation, or should they demand airtight proof before granting release? Judge Simpson seems open to the idea, but without clear documentation, approval becomes difficult. And uncertainty in court almost always leads to caution.
An offer requesting home confinement was also sent to the prosecutor for her consideration as well to see about a stipulation to the request. And so I would just be asking for your consideration as well. It's my understanding that Ms. Tenha is leaving it to the discretion of the court.
Where would he be?
Up on Gulf side. I have a 2-bedroom up there, sir. Tom from Community Mental Health has the key and is ready for everything for home.
When did that happen?
I'd have to pull up the,
Well, no, when,
I'm sorry.
that's not the address that we have.
I think, Your Honor, that might be the address he set up with Mr. Kloss. I don't know what address that he may have given for arraignment purposes. And I'm certain that that was likely different. Is that correct?
Yeah,
Okay.
yeah, that was a different one. The person's unable to do anything, but Tom Klaus has the key and has everything ready for home confinement.
So, my understanding, and maybe Mr. Bell, you can correct me if I'm wrong, this is my understanding speaking with him this morning, that this individual from CMH has confirmed that he has an apartment with a key for Mr. Melton. And that if he were to be allowed to home confinement, that's where he would go. CMH not only would have that address, but would be providing services there. For the record, I don't have any documents. I'm relying on representation. But Mr. Bellinger that he has that information.
Why did you get a different address? Oh, because I thought the person might be able to let me stay.
Okay. Understood. Your Honor, to clarify further, during the arraignment, he gave a different address to an individual who he assumed would allow him to stay and reside with that individual. That address that he's now given to Mr. Kloss for purposes of home confinement is an address that he's had for a place that he's had for a year now. So it's his own place.
Yeah, and
On Gulf side?
I'm sorry,
On golf.
on Gulf side, sir.
He's had that for a year?
He's had his own residence for a year. I don't know what the circumstances were at arraignment to the extent that he couldn't go back there or why he.
What is the Arbondale address?
At this point, everyone in the courtroom is trying to piece together the housing situation, and it becomes clear communication gaps are causing problems. The defense argues Mr. Melton has stable housing, while the judge points out the court has no concrete proof. Judges must rely on records, not verbal assurances, because release decisions affect community safety and accountability. Notice how Judge Simpson isn't hostile. He's cautious. He even signals willingness to approve confinement later if proper verification arrives. That's judicial balance in action, protecting the community while still giving defendants opportunity for support and treatment. Here's a key takeaway. Many courtroom setbacks happen not because requests are unreasonable, but because paperwork or confirmation isn't ready at the right moment. Timing matters in court. And let's ask viewers, should courts prioritize giving second chances, or should strict procedures always come first? That question sits at the heart of countless courtroom decisions, including this one.
The Arbordale is where I used to live. I lived there for, I had the address for 22 years. Never missed rent.
This get you, did being in custody get you evicted from that location?
No, no.
Okay.
We were already to Gulfside.
Okay.
We were already getting out of there.
Who is we?
Tom Klaus was, and we were moving out of there
So was Tom helping you do that through CMH?
through CMH.
Okay.
Yeah, it gets into this whole thing that it
Okay.
does. Yeah.
Your Honor, if I may, just briefly.
Yes, please.
So what we would want for Mr. Melton is to receive CMH service.
Yes, correct.
If he's able to do so in a way that keeps the community safe and keeps him out of trouble, we are all for that. We understand that we always want to strive for the least restrictive means we can do that. If there is a CMH person who has indicated to Mr. Bellinger that he has a key and everything is set up for home confinement, we will leave it to the court's discretion. What I failed to ask Mr. Bellinger, and I apologize, is whether he's had direct contact with the CMH person, or if this is all relying on Mr. Melton's explanation, because there obviously have been some issues with that in the past. So if we can kind of clarify on the record that Mr. Bellinger has been in direct contact with Mr. Klaus with CMH and has received information from him that Mr. Klaus has a key to an apartment that is ready, that would be appropriate for home confinement. We will look at the court's discretion.
Your Honor, it's my understanding that Ms. Baltima from our, the social worker from our office has had and been working with him and has had that direct contact. I have not personally had the direct contact, however, someone from my office has.
Okay, so here's what I'm going to suggest. I'm going to, at this time, deny your request.
Okay.
However, I'd suggest that you work with the prosecutor's office, get that information to them. You've heard their position. And I
Certainly.
think that's an appropriate position, that if there's some place that's safe that is appropriate for home confinement, that's fine. But right now, I don't have anything concrete that says he has an apartment on Gulfside, and there's a lot of them there.
Understood.
All right.
Thank you, Your Honor.
And with that, Judge Simpson delivers the final word for today. The request for home confinement isn't rejected permanently. It's denied for now due to lack of confirmed information. That distinction matters. Looking back, today's session showed two major courtroom themes: personal responsibility and procedural precision. In Mr. Beach's case, courtroom behavior and communication strained patience, while Mr. Melton's case showed how missing details can delay potential release opportunities. Judge Simpson consistently emphasized responsibility, listen to counsel, provide clear information, and come prepared. Courts operate on facts, documentation, and credibility. When any of those falter, outcomes become uncertain. The broader lesson: courtrooms aren't just about law. They're about perception, preparation, and cooperation. Every word, action, and decision shapes what happens next. So let's bring it home. Who do you think handled their situation better today? And what would you have done differently if you were standing before the judge? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.